apology that I have to make, but there is one serious error in that written submission. But wherever I have referred to Jammu and Kashmir, please read merger as accession, not merger, because Lordship has seen Kashmir did not merge. So that's the error which I have committed, which I want to rectify it. Wherever I use the word in my written submission, merger in respect of Jammu and Kashmir, it has to be accession. Now, Lord, I'll take just 2 minutes to sum up the context part, which you Lordship must have seen. Kashmir, Lord, acceded differently because it acceded post August 47. The rest of the states concluded their accession as well as standstill agreement before August 47. Because standstill agreement was a precondition for instrument of accession. So they had all signed. Kashmir did not do it. And therefore, as per the cabinet mission memorandum 25th May, as well as the India Independence Act 1947, section 6 and 7 and 8, Kashmir acquired independence because the paramountcy ceased on 15th of August 47. That's the crux of the cabinet mission memorandum and the India Independence Act that follows it.
Yes.
The rest of the states barring Kashmir merged through agreements from time to time with the Dominion of India, ceding all their powers and sovereignty, barring Kashmir. And that is what Lordship would notice in the instrument of accession. I would not take Lordship through it, but that is what Lordship noticed. All the states, unqualified cession of sovereignty to the Dominion of India. Some ceded directly to Dominion of India states, Rajavans. Some ceded the Dominion of India while they merged with the provinces. Provinces, Lordship would know about the provinces under the Government of India Act, and they automatically merged in the Dominion of India. And some ceded to the Federation of States, the Union of States. But eventually, all these ceding rulers and states, Indian states, they accepted that their right to make constitution, which was guaranteed to them in the cabinet mission memorandum, and thereafter under the India Independence Act and the negotiations. They all ceded that Constitution of India will not be the sole constitution, with their constitution merging in the Constitution of India. And that is what is not the genesis of Article 238. Article 238 is significant, and this will answer one of your Lordship's query, that what was the status of Kashmir when it ceded to the Dominion under Article 1 and the schedule.
Where will we get Article 238 actually? Where will we get the, because our constitution copy doesn't carry it. So if I'll just check.
Not that.
It doesn't have in this, yes. I'll share it with Justice Court. Is it anyway in the compilations? In the compilations, do we have it somewhere?
I have copies of this, but I brought copies of the
anyway, no, don't worry, we have it here.
You all rely heavily on Mr. Shankar. So very adept at these things.
The Constitution as applicable to the state of J&K have that?
I'm sorry,
Will the Constitution as applicable to the state of J&K have that? No.
No, 238 is in the Constitution of India.
And it can't have it because it's barred.
Yes, that's fine.
No, I'm coming to that. I'm coming to that as a slight something to be said. Lordships would bear this in mind that Kashmir ceded and became part of Union of India as Part B state. And all the ruler states were part of Part B state. I mean, they were all Part B in the schedule, first schedule. And therefore, 238 was made applicable to Part B states only, which were Indian states. Only what 238 does was, it keeps the promise of applying the state's constitution to the government, to the union, the Constitution of India. Part B state, 238 says that Part 6, 7, and consequently Part 11 will also apply to these Part B states. And that is how not all these Indian states merged unconditionally into the Constitution of India. Initially, all the Indian states were promised that they will have their constitution. But then through negotiations, this was taken out. My old vision wasn't.
Yes.
Now, the status of therefore Kashmir was of a Part B state in the year 1950 when the Constitution was enacted. And yet, Lordship would notice in 370, Article 238 was excluded. That speaks volumes about the autonomy of the state.
Yes.
Therefore,
Just hand these up, you know.
Are these given on a returnable basis or on a non-returnable basis?
That's what I got. In fact, when we were arguing Boileau's matter, we were looking for Article 31 and it wasn't in the footnotes. So when we conceived this constitution, we had to put all the old provisions. So
but the only discrimination my friend has is I have been
You want me to have a later edition of this?
it's coming out in 3 days.
But the original, the intention to gift me was not there.
Attorney is very upset that attorney is being discriminated against.
No, you have mine, I have one.
Copy, I can
Ah.
turn it with my own
My
camera.
brother has his own copy.
I have my copy.
No, the Tony should be penalized for gifting us all. Now coming back to the number of this brief introduction was necessary because the basic theme of ours is that the Kashmir was entirely different, and this is what Lordship would notice in the debates.
It's all when it is open to the process.
Kashmir was different, both in respect of accession to Dominion of India when it ceded at a different point of time as an independent state or a nation. And it was different in the sense that it did not merge, unlike the other states, its sovereignty. And that is why the Lordship would notice in the instrument of accession, which was negotiated by Kashmir, the ruler. There are a couple of clauses which are not there in the other instruments of accession. Format is the same under 1936 35 Government of India Act, but the conditions which were added in favor of Kashmir were not there. For instance, we are not bound by any provision of the Constitution of India, future Constitution of India. The internal sovereignty rests in the ruler. The Union of India cannot acquire land in Kashmir. Kashmir would acquire for Union of India and give it. Now, from here, noticing these important issues, Lordship may I'd like to answer Lordship's query, which fell from one of the Chief Justice. The sovereignty aspect. And which eventually will answer not Justice Khanna's query, also the superior and inferior constitutions. Eventually. Now, but the first aspect that we have to keep in mind is, his sovereignty was retained by the Raja in the instrument of accession. Lordship has seen that, so I would not waste a Lordship's time. The concept of sovereignty is a variable concept, Lord. Concept what it was in the 19th century, 18th century was no longer there in the 20th and 21st century. When the written constitution started coming in, and the democratization of autonomy, as my friend puts it, Lord, that's a very phrase pregnant with meaning. Democratization of authority and power, which is autonomy. His sovereignty being a variable factor has two components, the internal and the external, and there are two decisions which Lordship may just care to note. One is 1953. 1953, PEPSU, PEPSU, full bench, which deals with a similar situation where Patiala as an estate merged with British paramount still. Then what was the position of sovereignty of the Raja?
The page, Mr. Dwivedi?
Page 730. 14, please listen to what I'm saying. Please listen.
You can give us page later, no problem. You can just have it.
739. 739.
739. What is the principle which it lays down?
I'm sorry, not this. 1953, PEPSU 1. But I'm sorry, not this confusion arises.
No,
because
It's AIA.
Is it in the, any compilation?
Yes,
Case law compilation?
Yes. Which says the sovereignty comprises of two parts. Mainly because you have ceded external sovereignty, defense, external affairs, and communication, it would not amount to ceding of internal sovereignty.
And what is the second judgment?
The second judgment note is a recent judgment, 2000, volume 8, SCC 61.
Repeat the citation, please.
2000, volume 8, SCC, page 61, paragraph 31 and 2.
Paragraph?
31 and 2. 31 and 30.
And where was this in the compilation? Where will you get it?
But I'm sorry, it's not there in the compilation because
It's easy.
later research not yielded all these results.
Page 61.
Given paragraph. And I don't have time. And the third judgment in this regard, which is a clear pointer towards where the sovereignty rests post-constitution, the internal sovereignty, that is 59 Supreme Court, PN call.
KR 59 Supreme Court? Or?
PN calls case.
Oh, yes. That is case law compilation?
Page, volume 1, page 8. PDF page 8.
We have seen that, yes.
That's the situation with regard to sovereignty. It's not that the Kashmir lost all sovereignty merely because it acceded. And neither inclusion in the Article 1 and the schedule would result in loss of internal sovereignty. Now, the key part of my argument is based on, and the key question which I'm raising is, that Article 370 ceases to operate once the Constitution of Jammu and Kashmir was enacted on 26th of January 1957. It is somewhat different from what most of my friends have argued. They want some part of 370 to survive post 57. My argument is nothing survives. All the powers conferred under Article 370, I would show would cease to operate once the Constitution is enacted. And in that context, we have to keep in mind the object of 370 and the commitments made by the Dominion of India then and the approval of those commitments by the framers. But we must bear in mind that the people governing Dominion of India were mostly the same who were the framers of our Constitution. And they were wise men. We always say framers were most wise, dynamic, and sagacious. But then when it comes to the commitment made by them, we forget their sagacity. And therefore, I would pray, please permit me to place the debate of Dr. Iyengar, that is most crucial for my argument, and juxtapose it with 370, then I'll show one by one, all of the provisions become otious. So this is something which is a must for my argument, and I'll pray, please permit me.
Instead of reading, us reading now Mr. Iyengar's debate, his address, so we've read it 3 or 4 times. If you can cull out, and we'll take it down, if you can cull out what are the key parts of what he said, so that and then we'll go on to 370.
Lord, the debate, if Lordship will see, the initial part says that Article 370, Clause 1, B1 and 2, these are provisions providing for consultation and concurrence of the government of Jammu and Kashmir. And it clearly says, debates clearly say, that this was an interim arrangement till the Constituent Assembly was constituted. Now, what does, with due respect, I submit not ask myself, what does this interim arrangement mean in respect of 1B1 and 2? If it was an interim arrangement, they said it is interim vis-a-vis clause 2, which says as soon as the Constituent Assembly comes into being, the final decision is that of the Constituent Assembly. With regard to A, the jurisdiction of Union and Parliament over Kashmir, and the Union's relations with the state, or state's relation, conversely, the state's relation with the Union.
So the first is jurisdiction of Union of India over Jammu and Kashmir. And second?
I'm sorry, but I can.
You said once the Constitution of J&K comes into being, the final decision
is that of the Constituent Assembly of Jammu and Kashmir, which was formed for framing of the Constitution. Clause 2 says
on 2 aspects, you say. 1, jurisdiction of Union of India over Jammu and Kashmir.
And the center and the state relations. The finality would be that imparted by the Constituent Assembly of Jammu and Kashmir. I'll place only those portions not from the debate which not unerringly lead to that.
All right, let's quickly see those.
Yeah.
If you can just give us the page reference. वो अपना जो laminated दे दीजिए जरा.
Kindly come to note volume 5, PDF page 79. I'm reading the
Volume 5, page 79.
I'm reading the internal page 424.
We'll just go to that in a second.
Have lots of got it. No?
Just 1 second.
किसने पाना?
Will that work?
What is the page?
That is volume.
Now,
one,
the
page
first part-
79. You're on the right document, but volume page 79.
The first part, of course, deals with the different situation of Kashmir, which resulted in this discriminatory treatment of Kashmir in favor of Kashmir. Then kindly come to the last paragraph. Last paragraph of that very page, no? Again, the classic begins like this, no? Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or wish to go out of it. That was the extent of right given. But let's keep that aside for a moment. Then last three lines of the paragraph, last 4 minutes, we have also agreed that the will of the people through the instrument of a constituent assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. That's a very clear indicator. Sphere of union jurisdiction over the state will be determined by the Constituent Assembly. Lord, Lordships have gone through it, my friends skipped through it, but then the important aspects have remained uncovered. Therefore, I was. Then kindly come to the next paragraph, which is even more significant. And this represents clause 1B, 1 and 2. At present, the legislature, which was known as Praja Sabha in the state, is dead because the situation was such in Kashmir at that point of time, nothing could be functional. Neither that legislature nor the Constituent Assembly can be convoked or can function until complete peace comes to prevail in that state. We have therefore to deal with the government of the state, which as a representative, as represented in its council or of ministers, reflects the opinion of the largest political party in the state. Till the Constituent Assembly comes into being, only an interim arrangement is possible and not an arrangement which could be brought into line with the arrangement that exists in case of other states. Now, the word interim arrangement follows their elaboration that neither the Constituent Assembly is convoked nor the Legislative Assembly is there under the 39 Constitution, which is Praja Sabha. Therefore, whom should we consult? We are forced to consult or get the concurrence of the government, which is the only representative body, till the Constituent Assembly comes. This leaves no room for doubt. With regard to 1B1, 1B2, and even 1D, I'll show. All those provisions which provided for consultation and concurrence with the government of India, government of Kashmir, cease to operate only till the Constituent Assembly is not there. No sooner it comes into being, it ceases to. Then, Lord, the next paragraph, which is a short paragraph, further corroborates that impression. And it further indicates that 306A is also a temporary provision. Not all this argument, Lord, it has become permanent. We are giving meaning to the word temporary used in the constitutional provision towards the context, the object. Please have this. Now, if you remember the viewpoints that I have mentioned, it is an inevitable conclusion that at the present moment, we could establish only an interim system. 306A is an attempt to establish such a system. Now, what else does temporary provision mean? It's an interim provision. They're saying it in so many words. And yet what we are trying to do is make it permanent, changing the entire text of the Constitution. No, 306 lordships, no. Sure, I mean, sorry. For a second, no? The Constituent Assembly is always regarded by us as the most august assembly ever in the history of our assembly, and they evolved the Constitution. They were men who fully knew what Constitution means. When they say, you know, the Kashmir would frame its own Constitution, they could have not implied anything else except what they were doing.
All right, we now take this point of yours based on those two extracts from
Right.
Mr. Gopal Swami Iyengar's speech. Now, you still want to refer to further something here in his speech?
Yes.
All right.
Kindly have not omit the next paragraph, Lord, that is 238, so I've already elaborated. So,
Yes.
Then come not to the next one, not the paragraph. The second portion of this article relates to the legislative authority of Parliament over the Jammu and Kashmir state. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to three subjects of defense, foreign affairs, and communication. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they number some 20 to 25. Now, these items have undergone a change in the description, in numbering, in arrangement as amongst themselves in list 1 and list 3. But this is the justification of putting list 3 in 371B. Now, these items, no, I'm sorry, it is therefore necessary that the items mentioned in the instrument of accession should be brought into line with the changed designation of the entries in list 1 and 3 of the new constitution. So clause 1B of article 306A says that this listing of the item as per the terms of the new constitution should be done by the president in consultation with the government of the state. Then kindly come to clause B2, that is for concurrence. Clause B2 refers to possible additions to the list in the instrument of accession, and these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, kindly notice again the same thing comes. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition is the government of the state. Now, if I am not to read this and if I draw an inference from this, the only inference is that even B2, for all those provisions where concurrence is required of the government or consultation is required of the government, for adding anything to the instrument of accession, whether in terms of list items or in terms of other provisions. All the provisions of consultation and concurrence were interim till the Constituent Assembly meets. This
Dwivedi, just also read the next clause. The
Aye.
last clause refers to. And thus the Constituent Assembly, when it is referred to in the last sentence of that clause, is
Yeah,
an
I-
indication that the Constituent
is
Assembly
reading-
may continue. It's at page 427, internal page.
No, I'll come to that. Please bear with me. No, I'll explain that. I'll explain. I have that in mind. No? But I'll bear.
And whether the Constituent Assembly, when used in the last sentence of that paragraph,
Yes.
will be in the indication that
Even
probably,
is in our favor.
probably the Constituent Assembly over here was meant to get prolonged also.
I'll answer that. Then having seen this, no, that the consultation and concurrence were only for a temporary period till the Constituent Assembly comes into being. And that is what Lordship may now fall back on the Article 370 Clause 2. Clause 2. No, but this submission of mine tends to show to Lordship's note that both the provisos again provide for consultation and concurrence because they govern clause 1B to 1D. And therefore, no sooner the Constituent Assembly, as per the intent of the framers, comes into being, they would continue to operate because that's the only agency left for consultation and concurrence. But once it comes, then the consultation and concurrence has to be with the Constituent Assembly. That is what clause 2 says.
Mr. Dwivedi, I don't want to rush you. We started at 10:40 today. The time allotted to you is till 11:25. We are now about 11:12. So you'll have to, everybody will have to stick to time today. So
Lord, I'm obliged, Lord, Lordship has granted me this much of time, but please bear in mind, if I'm saying something which has already been said, Lordship has stopped me. But if there's something which perhaps is new or different.
All that I'm saying is we need not read now the rest of Mr. Iyengar.
Not. No. But the Iyengar statement is relevant because it answers the Lordship's query as well as not the inferiority and superiority of the Constitution of India. Also, I'll show.
That
So
speech we
according
have read at least twice, thrice.
I will.
That speech we have read at least twice, thrice before.
But your contention really is that once the Constitution of Jammu and Kashmir was framed on 26th of January 1957, the entirety of 370 ceases to exist.
There's nothing left. No.
And then the only governing document is the Constitution of Jammu and Kashmir. We got the point because they'll have to answer that.
We cannot ignore the fact what was the commitment made. When we see 370, it has to be in the light of the commitment made to the people of Kashmir.
Now, Mr. Dwivedi, can we go to Article 370 because we would like to dovetail this speech with 370.
Extremely obliged. Kindly have Lord 371.
371, yes.
A. First, the heading is temporary provision. Under the heading temporary provision,
Which are the features of 370 which according to you would indicate that it would cease to exist after the Constitution of J&K has been framed? Which are those? You can just identify them.
if we read the debates and dovetail it over here, it will be apparent.
Yes.
Not 238, the provisions of 238 shall not apply in relation to the state of Jammu and Kashmir. This provision has ceased to exist in the Constitution of India from 1957 onwards. But it has not been changed for the reason that there is no power to change it. Clause 3 requires Constituent Assembly, Clause 2 requires Constituent Assembly. And therefore, what my friend was right, Dr. Dhawan, when he said 52 onwards, Clause 3 has not been used. 238 is an amendment to Article 370, therefore Clause 3 was the only provision available. And it has not been used and it is allowed to exist because there is no way you can change it.
Because for 370, you have to amend 370, you have to fall back on clause 3.
Yeah, they have to. But they can't because the precondition for exercise of power is there. Now, Lord, kindly have Lord B, 1B1. That is a one-time power, Lord. There's no dispute about that. Once you determine which are the entries relating to instrument of accession, power ceases to operate. But yet it continues. No one has deleted that. Again, the same logic. Then comes 1B2. Such other matters in the said list, with the concurrence of the government of India, not government of Jammu and Kashmir. Now, reading the statement of Dr. Iyengar, which I placed for much. This is an interim arrangement because at that point of time, there was no other authority to consult or concur. Until the Constituent Assembly comes into being. And that is why 2 comes in. Lord, even I'll go to the extent of saying, Lordship would see logically, clause C also ceases to operate. Article 1, it says the provisions of Article 1 of this Constitution shall apply in relation to the state. Reason being, Lord, 370, Lord, when the Constitution comes, it itself says we are inalienable part of India. And for the federation purpose, Article 1 was there. So we can read both the statements together. There is really no need to go fall back on C. Lordship has seen, Section 3 of J&K Constitution, including the preamble, loudly pronounces them. We are inalienable. And this provision, Section 3 cannot be modified under 147, Section 147. which is the mandatory power of the Constituent Assembly. It's a basic feature of that constitution, therefore, which is not prone to amendment. That position is settled. Now comes note D. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify. Now this, Lord, immediately refers to the second proviso. First proviso I have already shown is the same thing as 1B1, where the word consultation and concurrence itself is embedded in the provision. So it's more or less reiteration of that. Second proviso says, no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. And Lordship has seen, Lord, the very initial part of the concurrence and consultation was brought in only because there was no other authority. And therefore they said until the Constituent Assembly comes into being. So therefore, in my opinion, Lord, humble opinion, subject to what Lordship decide eventually, even 1D becomes ocious. That power cannot be exercised because the concurrence now has to be by the Constituent Assembly. It cannot be, and that is what T2 says. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly for the purposes of framing of the constitution of the state is convened, it shall be placed before such assembly for such decision as we take. Therefore, even the concurrences and the consultations that have resulted into something, the finality of decision is vested in the Constituent Assembly. It can overturn that concurrence. And that is what the framers say in respect to clause 2, that the finality for determining the status of union and the state relations, as well as the jurisdiction of parliament, rests in the Constituent Assembly, who will finally determine these things. Well, Constituent Assembly would finally determine through the shape of Constitution of Jammu and Kashmir. It can't finally determine otherwise. Final determination has to be the enactment of Constitution, which was done. That is why I wanted to place the other paragraphs now, where they have said this in so many words. The final determination would be that of Constituent Assembly in respect of parliamentary jurisdiction over the state and the union's relations with the state.
Clause 2 does not give finality to the decision of the.
I'm not saying, as I said, please juxtapose the provision with the debate, and the debate says that.
So in other words, we'll be reading an ingredient of finality from the Constituent Assembly debate.
But I'll ask myself.
How can that be?
If the debate says that's the commitment, because Jammu and Kashmir Constituent Assembly will determine the constitution, what is the use of the commitment not made, and what is the use of the constitution when it cannot finally lay down anything? Just look at it this way, Lord. Unless we see 370 in the light of the commitment made, and the commitment was to framing of the constitution.
Can we say that a speech or an address made by an individual member of the Constituent Assembly, however weighty, represents a commitment by the nation or the Dominion of India to the state of Jammu and Kashmir? This would have a bearing on the interpretation of the constitutional provision.
My answer to this is not when we try to see.
But for us to raise it to the point where it's a binding commitment a speech by a very distinguished member of the Constituent Assembly represents a binding commitment of a nation.
But that statement is not by any member. That was a statement on behalf of the person who answers all the queries on the amendments made. That's a difference.
Diwedi, what you're asking us to read into it is something which is not there in the article. But if the article was that this article will get frozen in point of time after the Constituent Assembly of JNK frames the Constitution, that doesn't appear to be following. Because that's why I said come to page 427, and that makes it very clear. Because you are reading, we can't read a portion of the debate without going through the entire,
Your Lordship,
what
please
has
read
been
the
said.
last paragraph and I'll explain.
Not the last, yes, the last claim, the last clause.
The
Just read
effect of
that.
this article.
Yes, just read that. You can't
The
read,
effect-
because you can't read portions, dehouse the other, because when this debate is going on,
Fine.
there can be statements and then the explanation to those statements.
Now, Lord, may I answer it in this way?
And the other part is, you see, once you become a part of the nation, become part of it's the entire nation, then you are part
No,
of.
this is what is creating a problem, Lord. Are perhaps thinking in the manner which we have been tuned to think for last 70 years, Lord, is that one nation, one constitution. But where is that prescribed, Lord? I ask myself. Accepting it could be prescribed in the Constitution of India, but Constitution does not say so.
Anyway, just read that paragraph.
And the effect of this article is that Jammu and Kashmir state, which is now part of India, will continue to be part of India.
No, the one before that. The last clause refers to what
Right.
may happen later on.
The last clause refers to what may happen later on. We have said Article 211A will not apply to Jammu and Kashmir. This is Article 238. But that cannot be a permanent feature of the constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution of the state and on the range of federal jurisdiction over state. Can you notice that? State, the president may, on recommendation of the Constituent Assembly, issue an order that the Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. Now, Lord, I ask myself this question.
Just read further in the last paragraph there.
But before he issues any order of this kind, the recommendation of the Constituent Assembly will be a condition precedent.
Correct. Now read the next paragraph also.
Well, the effect of this article is that the Jammu and Kashmir state, which is now part of India, will continue to be part of India, will be a unit of the future Federal Republic of India, and the Union Legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state, and steps have to be taken for the purposes of convening the constitution. Lordship may not detach one line before the succeeding line. It says concurrence of the government, and then effort should be made to establish the Constitution of India. So this is what, I mean, the Jammu and Kashmir, the Constituent Assembly. Now, Lord, if your Lordship would read it with the first part and this part, Lord, after all, they are elaborating. So we can't detach the first part from the last part. So we are not, with due respect, Lord, we cannot snatch away this part, Lord. Steps have to be taken for the purposes of convening the Constituent Assembly in due course, which will go into matters I have already referred to. In other words, Lord, all this is talking again of that interim period. The concurrence, and otherwise, Lord, the first part says concurrence ceases till the Constitution comes into, Constituent Assembly comes into being. And if we read later part as saying that no, it will still continue, that there's a contradiction to that, Lord. And therefore, Lord, my cohesive reading shows that perhaps when they gave this, Lord, this power of consultation and concurrence to the government, it was in a peculiar situation, not beyond that. And that is the key. As I said, Lord, that was the key to indicate what was the scope of 1B1 and 1B2, including 1D, the two provisos. And it's nobody's case, Lord, 2 and Lord, clause 3 survive beyond 1970, not 57?
After the Constituent Assembly took its decision on 26th of January 1957, the Dominion of India would have no power to apply any other provisions of the Constitution to Jammu and Kashmir.
They have all the powers. As I said, Lord, if your Lordship would see the 44th Amendment, which is the basis for Constitution of Jammu and Kashmir. That gives, Lord, Union of India all the entries, Lord, which it has under the Constitution of India, 1 to 96. Excepting 97 is not there because residuary power is there with the state. Section 5. That was not, I'm not here to judge whether they were right or wrong. I'm here only indicating to your lordships, Lord, that this is one of the intents clearly falling from the interpretation which they had given to 370 only. And we have always argued, Lord, we have always said, look into the debates to cull out the intent of the provision. So all that I'm saying is kindly look into the debates to cull out the intent of 370. And when we see the debates along with 370, it clearly emerges that his power is not available thereafter. And that is where I submit with respect, Lord, Sampath Kumar is wrong. Lordship, I have indicated in my written, Sampath Prakash. And the biggest mistake committed by Sampath Prakash, if Lordship would see, is they relied upon 1952 presidential order, which incorporates, Lord, that the explanation, if Lordship would see 370 explanation, that was what was incorporated by Sampath Prakash, modified. Initially, it was the dynastic rule that the president will recognize the Raja as Sadr-e-Riyasat. But 52, Lord, the Constituent Assembly, Lord, moved a motion and abolished this dynastic rule and said now Sadr-e-Riyasat would be the elected by the Assembly or on the advice of the government of Jammu and Kashmir. Now, Lord, this was sent to the government of India with the concurrence of the Constituent Assembly under clause 370. And it was incorporated in the form of an explanation to one that Sadr-e-Riyasat would be. Now, Lord, the Sampath Prakash assumes that this 52 order, Lord, continues the Sadr-e-Riyasat, and therefore it shows that they wanted permanence to 370. But they erred in one respect, and something which was not pointed out to them. Kindly have section 27 of the Jammu and Kashmir Act.
So Diwedi, your submission is that defunct provisions of the Constitution, 370 was a defunct provision of the Constitution. No purpose in having it there, yet it continued to be there. Everything would be determined by J&K Constitution.
I'll answer that.
COs have been issued from time to time, pre-57 and post-57.
I'll answer.
And yet, nobody thought about it. Yet the so-called affiliation with 370, a section of the people feel, was also negatory because nothing survived.
Lord, may I please permit me to answer this.
Difficult to go
which
that
has
far.
come from your lordships, not that the past practice is going to justify the invalidity of that.
Past practice.
That's not the law. Laws, as I understand, is howsoever long the past practice may be, if it is constitutionally illegal, then it cannot be justified. And I'll show, not here, kindly have section 27 of the Jammu and Kashmir Constitution. It is volume 20. Not howsoever much we may not like it, we may not approve it, but the fact remains, all that I'm trying to show is the intent. And should we read Article 370 divorce the intent? No, that's my question.
We read an intent based on the constitutional law debates.
But that's
how it transpired after that, how it is worked out is, you say, irrelevant completely.
That's why I said, not any amount of illegality or action that may have been taken subsequently cannot justify the invalidity. Once it is, I'll show.
Yes, what do you
But
want?
questions can never be not the.
Which volume do you want us to see now?
Yes. Kindly have not volume 20.
Page? What page would that be?
PDF page 310.
Page?
310.
PDF page note 310. But I know, Lord, I'm advocating a cause which may not sound very, I mean, in fact, which may not sound.
No,
pleasant.
it's
I
not
was
that,
conscious
it's
of
not
it.
that, please.
I was conscious of it.
I know. You see, the explanation which was added in 1952 refers to the Council of Ministers.
I'll answer that.
It refers to
have
the,
27.
but it doesn't refer to the Constituent Assembly.
It does.
And it doesn't refer to the Constituent Assembly.
It does.
Explanation. And it defines the expression government of the state for the purpose of that article.
Yes.
It defines the expression government of the state for the purpose of that article.
And that is with the concurrence of
And-
constituents.
And there lies the distinction between the Constituent Assembly
But
debates, because
kindly let me
Constituent
complete.
Assembly debates are not relevant as far as the explanation is concerned.
That's not correct. This is what I'm saying. Kindly have section 27.
What
Lord,
I'm
this
finding-
Sadr Riyasat in that form continued under Constitution of Jammu and Kashmir.
One thing I'm finding difficult to accept, you
Man.
persuade, is
I
that,
know, Lord, it is difficult.
no, I'm saying so that the Constituent Assembly debates amounted to an assurance that 306A or 370 would dissolve itself.
I'm not saying that.
And whether after that it did or not, it has dissolved itself.
No, that's not right way of putting my question, not my answer.
If you say 370
No,
is
I'll
there in the
answer that.
statute, then it dissolves, it's
No, what
automatic.
I'm saying is, Lord, debates indicate the intention behind 370 and the scope of 370. Because it's very common, Lord, every time when we see this, Lord, want to investigate and go into the question of intention of the framer,
I thought you said 370 doesn't exist. According to you, it's
Yes,
only
yes.
on paper, it doesn't.
post 97, post 57.
Yes, yes. So I am saying what you say is the constitution debate should be read in a manner that 370 was intended to dissolve itself on the Constituent Assembly, completing the J&K Constituent Assembly, completing the process.
No,
And
but-
it has inadvertently remained on the statute, over which some people
that-
seem to
that-
be very,
Lord,
let me say better words, feel very strongly about 370.
fair diplomat, my lordships, Lord,
Oh,
just say
putting-
lordships would
I
have
am
your
putting
lordships
to you the
opinion, Lord, I can't
consequence.
say.
I am putting to you the consequence, what would happen
No,
were we to accept what you are saying.
But
This is
what
what I'm
would be
only
the
trying to
consequence?
put it
Lord,
in
I ask
perspective.
myself, Lord, I don't feel that there would be any adverse consequence, Lord. Once we accept, please keep this in mind for a moment, Lord, that yes, two constitutions could have separately existed cohesively, Lord. But what will be the consequence, I ask myself, Lord? And that was the intent of the framers, and they felt, Lord, eventually Kashmiris may agree to something which is like other states, but then they didn't enforce that. They still permitted constitution to be framed. But constitutions are not made for a day, lordships have held in 2018. They are made till the lifetime of the state or the nation. They're not made for a day or two. They can't be held to be an interim measure, to be chipped off and on. Now, please have 27. Lord, what the Supreme Court in Sampath Kumar overlooked was that explanation did not continue. What continued thereafter was 27 section.
Really, the net consequence would be that the Constitution of India, in its application to the state of Jammu and Kashmir, would stand frozen as of January 1957. Therefore, no further development in Indian constitutional law can at all apply, according to you, to the J&K,
Exactly.
to the state of
I go to
Jammu and
that
Kashmir
extent because-
after 1957.
Because Constitution of Jammu and Kashmir
How
itself.
can that be acceptable?
We may ask this question how, but the question is which provision of the Constitution permits that except 370? Now, if I am right in my submission, the 370 ceases to operate, then which other provision would
But
take
if Article 370 ceases to operate and Article 1 continues to operate, and then Jammu and Kashmir is an integral part of India, surely the jurisdiction of every democratically elected institution in India is not excluded in its application.
What I am saying here again, let me reiterate.
There has to be then a provision in the Indian constitution which excludes its application to Jammu and Kashmir, and there is none then according to your argument.
This may be our wish, but the point is, let us look at the provisions of the Constitution. This is what I am saying.
Mr. Dwivedi,
In
70, your argument now cuts across the other side argument.
That's right, no? They
Your
are
side
subject to
argument
that.
itself. You're cutting,
They
you're
are
cutting
right.
at,
No, but
you see,
there's a difference.
and just look at the second proviso. Just turn to the second proviso.
Yes.
Except with the concurrence of that government, Now, the government has been defined, and the argument of your side, some of your colleagues on your side, is government, and the government of the day, council ministers, is different from the Constituent Assembly and the Legislative Assembly.
But this is where,
And here, the second proviso does not use the expression Constituent Assembly. It says except with the concurrence of that government. And government has been defined by pursuant to the amendment in 1982. And therefore, your challenge or to the dictum in Sampath Kumar is slightly, gets into difficulty. Because
But
that's the intent behind it.
may I answer that? No? When it says that government, what it means is the government which was preceding the Constituent Assembly.
That's
It
contrary
can't
to
be
the
any other
explanation.
government because then two falls.
That's contrary to the explanation.
I'll answer. But kindly bear with me. Why do I say so? After second proviso, there is clause 2. And what does clause 2 say? Whatever concurrence has been given prior to Constituent Assembly has to be placed before Constituent Assembly for enabling it to take a final decision.
What it means is this, that if there is concurrence, because initially when the Article 370 was there, it was Sadr Riyas and the other council. After that, at that time, if any decision is taken, it will be with that.
The asset continued.
I know, I'm aware, but the explanation which is added is with regard to then the Council of Ministers. The explanation in 1952, which was added by the concurrence of the Constituent Assembly, was with regard to the Council of Ministers.
So there's no difficulty, Lord. We are reading little, with due respect, Lord, we're reading little too much on that. Because have section 27 to 32. It is the Sadr Riyasat elected by the Legislative Assembly who will be the Sadr Riyasat. And obviously the recommendation goes through the Council of Ministers, not otherwise. So the Council of Ministers and Sadr Riyasat as well as Legislative Assembly are all there, elected. And then not by explanation, relying on the explanation to 1952 order, he cannot say in 57, Lord, Constitution does not seize 370, Lord, that doesn't follow because Constitution includes Sadr Riyasat. The continuance of Sadr Riyasat had to be as per section 27, it couldn't be, and that was the fact. So this assertion in Sampath Kumar, relying upon the 52 presidential order, adding the explanation of elected Sadr Riyasat is not correct. Lord, there are lots of misconceptions. For instance, Lord, in Damanu's case, which I think one of my friends may have cited that. Lord, please read clause 2 in the debates, Lord. Please read clause 2 in the debates, Lord. Lord, may I pay here? Lots of clarification would be there if your Lordship would read the explanation to clause 2 in the debates, Lord. Page 427, the same page. Page 82. Then we come to clause 2. The passages, Lord, paragraph. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir and the Jammu and Kashmir state. Now these relate particularly to matters which are not mentioned in the instrument of accession, and it is one of our commitment to the people and the government of Kashmir that no such addition should be made except with the consent of the Constituent Assembly, which may be called in the state for framing of the Constitution. In other words, what we are committed to is that these additions are matters for the determination of the Constituent Assembly. That explains Lordship's question. It may be second explanation, but it comes before clause 2. After reading the explanation in the clause 1D, they come to clause 2. Not otherwise, not the whole reasonable sequence denoted in the Article 370 has no meaning then. And this paragraph includes the second proviso. clearly. So inferring something different from that word, that government, my lord, to me, my lord, as I see it, my lord, it doesn't follow. And then also the next paragraph is equally, my lord, so far as the other thing is, yes. Just one paragraph, no? Now you will recall that in some of, and that has been done. That we have read. But kya hai? We have read. Now, my lord, as I said, Sampath Kumar was not, Prakash was not rightly decided. And if your lordship would just have a look at Sampath Prakash, my lord, that perhaps may eventually conclude my argument. Sampath Prakash is,
Which is the provision of the J&K Constitution equivalent to Article 245 or 246?
they have their own section 5, which defines the powers of both state and indirectly the parliament. Section 5, your lordship have. And this is what continued for a long period of time. If practice is relevant, not then this is continued for a long period of time till this order comes. Kindly have section 5. That is not for lots of convenience, but volume 2, PTA page. I may first refer to the preamble.
Now see the problem with your argument, because Article 5 says that the legislative and executive power of the state would extend to all matters except those with respect to which Parliament has power to make laws for the state
Yes,
under the provisions of the Constitution of India.
yes.
Therefore, that takes us to the Constitution of India.
No, the reason being
That therefore postulates that the Constitution of India does apply to the state of Jammu and Kashmir.
that overlooks one important factor, and that is the 44th Amendment immediately preceded with the concurrence of Constituent Assembly, where they had elaborately defined what are the provisions of the Constitution of India would be applicable to Jammu and Kashmir. And this constitution is elaborately based on that 44 order. And therefore it presumes whatever power has been given to the parliament under not the scheme of things, 44, there not what they have indicated is entries 1 to 96 of list 1.
But unless
I'll
for the purpose of the argument of this side, unless we accept that Article 370 did continue until 2019, there would be absolutely no trammel on the jurisdiction of Parliament under Section 5.
Not, as I said, not
Because 5 says, except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution.
but there's not.
Now,
I'll
under the
answer that.
Constitution,
Yes, very-
but for 370,
Yes.
Parliament would have the power to make laws with respect to all aspects in List 1 and List 3. Now, if your argument is that 370 goes,
Not the moment we come to
then
this,
where is the limit on the power of Parliament?
I'll answer. It has, Parliament has power to make laws. Now let us fall back to that stage. What was the power given to Parliament at that point of time to make laws? The 44th presidential order, 48th presidential order, which is 1954. It elaborately determines what is the scope of parliamentary jurisdiction. That is entry 1 to 96. Now, if we add entry 97 to that, again, because that is Parliament's power, then what will be the fate of Section 5?
But then you've been arguing all this while that these constitutional orders are a matter of constitutional practice. They're contrary to the provisions of they're contrary to the constitutional provision.
No, we have-
If we accept your argument and therefore don't look at the constitutional orders, then this is the consequence which follows as a sequitur of your argument, that there would be no restraint on the power of Parliament then.
The sequitur is this, Lord, that after the 1954 order, there couldn't have been any other order. And that is why they say in respect to which Parliament has power to make law. Otherwise not, again I fall back on the same theory, internal sovereignty continued with the state. The constitution ensures that internal sovereignty. There is a not the whole legislative provision, the executive provision, and the judicial provision. What is the utility of that law if 370 continues to infiltrate? As I said, not add entry 97. That is the residuary power. Then what remains of this? And yet the commitment was there. Not all that I am suggesting time and again is see it in the light of the object of 370, the intent. The object of 370 was only to ensure that no one from outside interferes with the constitution making. That was the object of 370 as the framers have delineated. So therefore, not otherwise, Lordship may see 254 doesn't apply.
Dwivedi, now I think we've really understood your perspective. Can we now wrap up?
Yes, yes. So Sampath Kumar, I've already indicated.
You have already argued Sampath Kumar, so we'll now.
Prakash.
There's some people who have to follow now.
It is wrong.
Thank you so much, Mr. Dwivedi. Thank you very much.
No, there's one aspect. There is one aspect which I want to throw light on, which fell from Justice Coleman. But since there has been repeated exercise of power since 1957 onwards, under 370, therefore that speaks of the validity too. We have to take that into consideration, if I have understood rightly. It can't be that the power was not there yet it was being exercised. Now, there are two authorities which I cite here. And one is which we could call out, because the argument fell from your lordships. Your lordship would permit me. What CJI has to say on that?
What is the proposition you are seeking to
The
make?
proposition is that howsoever long the practice may have been, acquiescence, howsoever long it may have been, that will never confer validity on the provision if the power is not there.
That may be, what has been put is not in that fashion. What has been said is if there are two interpretations which are possible,
No, not that. I'm not.
that's what was put to you.
What is being put is the way it has been understood by
No,
everybody.
as I said, not if two interpretations, let's
Now,
not.
at this stage, you say, no, all that has happened over the last so many decades
That's
is
what
wrong.
Lordship
Nobody
did,
understood the constitution of JNK, nobody understood the constitution.
That's what
of
your lordships did in Lord
What is being
Golaknath.
said.
That's what your lordships did in Indira Sahni. Not in Indira Sahni. No, please recall what happened in Indira Sahni.
All right, we've taken the point that
Yeah, I
the
understand.
constitutional practice will not legitimize a constitution.
That will not legitimize.
Fair enough. Thank you, Mr. Dwivedi. Thank you very much. We'll now go on to the next, Mr. Singh. Yes, Mr. Siv Singh now.
But there is one decision that Lordship just make a note of it.
Yes.
1961, Supreme Court. KIR 1961, Supreme Court, 964, para 1 and 2.
964.
What is the name of the case?
This is not Amalgamated Coalfields Limited. So just two paragraphs, no?
All right.
1 and 2. It's a constitution bench. Again, they said these are questions cannot convey any kind
Thank
of
you, Mr. Dwivedi.